Greetings all. Quite a few of our members and the community have asked about the Black Laws Dictionary, and a lot of the community are in Australia, and the Black Laws Dictionary is US centric. So thank you for asking about it. Zev at Warrior at Law talks about the Black Laws Dictionary. He prefers the fourth edition. But I thought we'd just speak into the practicalities and the reality of using dictionaries and resources like the Black Laws Dictionary um, on the ground. So, thank you to the living man who was the last person to ask this question, because I think that you've actually raised some really thoughtful questions about the role of the Black Laws Dictionary and Admiralty and Maritime law within the Australian court system. So, over the last few days, I've put together a breakdown that should help one clarify where it fits and what's actually recognised in Australia for those who are on the land commonly known as Australia. Let's not go down that rabbit hole. All right, so the Black Laws Dictionary is primarily an American legal reference, and it was originally published in the 1800s. If you would like a copy of that, it is on the Warrior at Law website. Go into the members area, become a free member, and you can download it from there. Now, in Australia, it can certainly be used as a tool to help comprehend legal terms. But in the actual court system, in their court system, it is not considered the top authority. So courts in Australia rely first and foremost on the Australian statutes, case law, and recognise local legal dictionaries. For example, look up the Encyclopaedic Australian Legal Dictionary. There isn't any formal training program for Australian judges in interpreting or applying Black Laws Dictionary. Judicial education here in Australia for them focuses on statutory interpretation, precedent, and procedure, not American definitions. So, sometimes a judge might refer to blacks for context. It's not binding or necessary for them to do so, however. So, let's look at this in practical terms on the ground. If you were to present a definition from the blacks in an Australian courtroom, the judge may accept it, but really probably only as persuasive, not authoritative. They will always prioritise definitions set out in Australian legislation or precedent first. Now, like I said, the Black Laws Dictionary is available in libraries, law schools, and anyone can purchase it. And we do have the fourth edition for free on the Warrior at Law website. So I always say go down the rabbit hole. There's loads of discussions where you can look at how different legal dictionaries are used. Legal research guides, the types of dictionaries are found publicly online. On the other hand, judicial training materials as such aren't generally made available to the public, are they? Of course. Now, in short, you can reference Black Laws Dictionary, but you'll need to demonstrate how that definition aligns with Australian law or established cases. So find case precedents. Courts in Australia will not rely on the Black Laws Dictionary alone. So Australia has a well-defined Admiralty and Maritime framework through the Commonwealth legislation, notably the Admiralty Act 1988. Now, this act outlines what constitutes a maritime claim, a general maritime claim, and the procedures for in rem or in personam actions. For example, vessel arrest or ownership disputes. Now, this is Zev's area, so I always listen to his technical mind and then try to put it into layman's terms. So, the Federal Court of Australia handles most admiralty and maritime matters, and it actually has a dedicated Admiralty and Maritime National Practice Area. So, only judges with specialised knowledge or experience in maritime law are assigned to these specific cases. That tells us there's a recognised level of education, expertise, and structure around this jurisdiction. Now, supporting legislation includes the Limitation of Liability for Maritime Claims Act 1989 and the Navigation Act 2012. These, combined with Admiralty rules, provide the procedural and legal backbone of Australia's maritime jurisdiction. Now, constitutionally, Admiralty and maritime matters sit under Section 51. The Commonwealth's power of overtrade and commerce with other countries and among the other states. So, I'm just trying to lay it all out in my brain before the words come out of my mouth. So, Admiralty jurisdiction in Australia is a long established and well anchored in both law and precedent. Where this becomes relevant is when legal definitions cross jurisdictions. For instance, if you're referring to a maritime concept that originated in English or American law, for example, maritime lien or charter party, you might use the Blacklaw's dictionary as a reference, but you must also show how the Australian law defines or applies the same term. So, in practice, the order of things is so important. Always start with the Australian statutory definitions. For example, check Section 4 of the Admiralty Act 1988. Back it up with Australian case law, ideally from the Federal Court or High Court. Now, then, if you still choose to reference Blacklaw's dictionary, you need to make clarify that it is a US definition, and then show how it aligns or differs from the Australian equivalent. This practical approach gives your argument both depth and jurisdictional grounding. So I'll say it again. Blacklaw's dictionary is not an authoritative source in Australian courts. It is an excellent persuasive tool. Australian courts and judges rely on Australian legislation, precedent, and recognised Australian legal dictionaries. Judges here in Australia aren't specifically trained in US legal materials like Blacklaw's, but Admiralty and maritime specialists within the Federal Court are highly trained in this field. Now, Admiralty and maritime law is absolutely recognised and implemented through Commonwealth statutes, practice notes, and federal jurisdiction. The Admiralty Act 1988 replaced the old British framework, including the Admiralty Act 1890, and that's the one that remains governing statute today. I will look up the Australian Legal Dictionary and see if I can put a copy of that on Warrior Law website as well. As you can tell, I've been speaking to half half a century. I was going to say half a century of members, which I mean to say 50 members this week so far, helping them with purpose, mission, legacy, and what they want to do and how they can find remedy. So forgive my voice. Be well, and I look forward to speaking to you soon. See you.